Deputy. I now call on Deputy Broughan.
Thanks, Cathaoirleach. I'm delighted to have a brief opportunity to speak about this very important bill, the Residential Tenancies Amendment Bill, number 2 Bill 2018. It's certainly a long overdue bill, Minister. In fact, it's probably about 35 years overdue. And it certainly doesn't go remotely far enough to vindicate tenants' rights and to create a fairer rental market in this country. But even the small steps in this bill, I think they are welcome as an attempt to begin to remedy the worst deficiencies in tenancy law and to face up to the horrendous situation that many tenants are placed in. Indeed, I've also liaised, I suppose, over the last couple of years with the Office of the Parliamentary Legal Advisor, OPLA, trying to frame a bill with a similar thrust. But in many respects, it was very difficult to bring one forward, Minister, because of the necessity, some people felt, to include a regime of administrative sanctions, which you have here in Section 7, and the fear that landlords engaged in criminal activity and in very bad treatment of tenants, that they couldn't be prosecuted if they'd been previously fined under an administrative regime. I know the bill is intended to give effect to the strategy for the rental market pillar of the unfortunately failing Rebuilding Ireland strategy, and it will amend the Residential Tenancies Acts 2004 to 2016 and bestow greater powers on the Residential Tenancies Board for investigation and sanctions, and it will also increase notice periods, strengthen Part 4 tenancies and provide for the registration of tenancies annually, among other things. Although, as you know, Minister, there's been, on that very latter point, there's been a lot of criticism by agencies like Threshold and others about that you had the opportunity to bring in a real-time register, and that so far you haven't been willing to grasp that. Back in mid-December, of course, Cathaoirleach, I spoke in strong support of the Solidarity People Before Profit anti-evictions bill, and I was very happy to see it pass the House and proceed to committee. That bill's provisions would have given, I think, much greater security of tenure, extended notice periods as well, forced landlords to pay compensation to tenants who'd been evicted due to family members moving back into the accommodation unit, and indeed introduce other improvements. Earlier this week, as many deputies would do, keeping a very close eye on the situation in housing and in homelessness, Minister, I recall I sent out a brief statement around the 8,000 homeless children that we have when we look at the official your departmental figures, the Department of Justice and Equality figures for direct provision, and the Department of Children and Youth Affairs figures for domestic violence refuges. So a total of something like 8,000, Minister. And earlier this week, we also, of course, heard from respected medics in Temple Street that the increase of 29% of children with no fixed abode attending the emergency department is linked to inappropriate living conditions that these homeless children are being accommodated in. Of course, many of them were just infants, Minister. And of course, behind each of these figures is a real child. Many of them very young, as I said, many of them infants experiencing deep trauma at the lack of security and stability in something as fundamental as a safe, forever home. And of course I meet many of them at my weekly information clinics, as I'm sure other deputies do, and you do yourself, Minister. Obviously I would be also ashamed, as I think this whole House would, at how the government is treating those children, a lost generation and indeed lost childhoods. And I'm sure we'll hear from them 20 or 30 years from now, when some of them will be in this House as well, to look back over this period. And on Monday, of course, I was struck when the Taoiseach spoke of his own failings in this regard, when he tried to embrace the famous democratic programme of the first Dáil and indicated we have to do better, we must do better. The reality is, though, of course, he's not doing well enough, and you're not doing well enough. We also know that the rental market and the unaffordable rents directly linked to the increase in homelessness and particularly family homelessness in Dublin, yet you've been moving at a snail's pace, Minister, to begin to address this. And of course, this matter, I mean, as part of our overall housing crisis, and even to get this far, I think it's taken 3 years of continuous debate and continuous questions to yourself and the Taoiseach and the previous Taoiseach in this House. The number of households, of course, in the private rental sector dramatically increased by 64% from 2006, between 2006 down to 2011, and 2017 we had a report. We learned that almost 19% of the total population was living in rented accommodation. Indeed, 30%, I think, of all occupied households were tenancy households. And I noticed also from one of the threshold reports from their studies that 45% of those tenancies were paying 30% of their income in rent, and an astonishing 14% were paying an astonishing 50% of their total income in rent. So these are very dismal, I think, figures on the record of this government and the previous austerity government. Of course, many people regard former Minister Kelly's rent pressure zones as a total cop-out, given that he wasn't prepared to insist to your party, Minister, that the ignoring of the pressure zone rent limits would result in serious sanctions. He wasn't prepared, in fact, to put the government on the line and have a general election. Single people, of course, and lone parents are well overrepresented in the private rental sector, and this has always been the case. As rents continue to increase quarter to quarter for 25 or 26 consecutive quarters, rents reached a peak 30% higher than during the Celtic Tiger boom in 2008. And much is made, of course, of the daft rent index reports versus the RTB rent index, with the government, of course, preferring the one that shows the lower increases. The important thing to note, however, Minister, is that both indices report increases, relentless increases. And average rents in Dublin are now over $1,600 per month. In cities, of course, our other cities in Cork, Galway, Limerick, and even Waterford were also experiencing huge increases. And of course, rent pressure zones, they were deliberately introduced without any way of really monitoring or regulating them. They were a PR stunt, in fact, by that government. And with so many exemptions, of course, that landlords have been able to flout the 4% whenever they wish. Constitutional rights to property and the protection of that property are often quoted when we are trying to come up with solutions, of course, to the ever-worsening housing crisis. But in reality, of course, Bunreacht na Éireann does allow for use of property for the public good to trump private property rights. And of course, many speakers, including your own leader, Minister, they made that very point on Monday afternoon at our 100th anniversary, meeting. But of course, Fine Gael and Fianna Fáil, unfortunately, so much in debt to landlords and so many landlords represented, they've always preferred to create situations to increase profits of landlords rather than to protect the well-being of tenants. And of course, our own republic, when we look back in the last 100 years, we did have the experience for lengthy periods, I think, as the Minister well knows, of rent controls. Before 1981, I think, under the 1960 Act, wasn't it? We did have a rent control regime, and we know that kind of regime could have been brought back again. You could do it yourself, Minister, to come in, as my Sinn Féin colleague said, and say for 3 years there will be no more increases until we get housing supply up to, what is it, 25,000 a year. And by the way, I'm still not clear, Minister, I think I asked you a question about that last week, but it wasn't reached. I'm still not clear, how many houses are we actually building? The last dismal figure I saw for last year, for 2018, was 12,000. And I think Deputy Fitzgerald told me we were supposed to be at 25,000 in 2018. She told me that when she was tarnished, I think around 2016, was it? So, I mean, it's still dismal, isn't it? We've so many plans, particularly in relation to social housing and particularly in relation to affordable housing. And we know, of course, there are excellent rental regimes around Europe where tenants have greater security and, in many cases, indefinite leases. Although there's a housing crisis in many countries, apart from Finland, which seems to have brought in a regime, Minister, whereby we don't have the current appalling homelessness, or they don't have that exists in so many other EU countries. But of course, basically, it's because of the commodification of the fundamental human right to shelter. Nevertheless, as I said, there are improved rental markets in our neighbouring EU countries. The rental sectors in Scandinavia, France, Spain, Germany, much better regulated. And I know that people might say that this bill tonight is a small step along the same road. 40% of people in Germany, as many people know, they live in the private rental sector. And I know the government policy is trying to steer people away from home ownership in Ireland towards longer rentals, but to do that we definitely need to have a functioning rental sector. I recently read a book which is in our library, Minister, by Professor Barry Needham, who teaches planning in Holland, and it's called Dutch Land Use Planning, the Principles and the Practice 2014. And it kind of clearly shows they go in for a lot of project planning and for the kind of major planning consistently that is necessary to produce for a country that's the size of Leinster and Munster, has a population of 17 million and growing, and obviously is very slowly trying to increase its land mass. They've evolved a lot of systems of how to manage, I think, planning and how to manage a sustainable supply of housing. But even there, Professor Needham says, of course, market homes, the developers of what are called market homes, they look for a 30 or 40% profit margin, and they don't care whatsoever about social housing. And of course, that's the experience we've had with an awful lot of our developers over the last number of decades. We had a welcome announcement by Facebook, of course, during the week that's to increase its workforce by 1,000. But, Minister, of course, again, where will these extra workers live? And if there's other Brexit-related jobs coming to this country, and let's hope over the next 8 or 9 weeks that the current fairly frightening situation in relation to a no-deal Brexit doesn't happen. But obviously, this is going to be an extra difficulty in order to produce those extra homes that this government will have to try and deal with in its final days, perhaps. Part 2, Section 3 of the bill, just come to the bill itself, amends Section 19 of the Residential Tenancies Act 2004 and sets out conditions for, and I quote, a substantial change in accommodation which can render it exempt from the rent pressure zone increase of 4% a year. And I have to say, Minister, that is a very welcome amendment. It means at least half a dwelling must undergo renovation. And reports, of course, in the past of landlords just putting on a coat of paint or putting in a new suite of furniture will not entitle them to the exemption. But threshold, and you probably read the threshold briefing and critique of the bill, they rightly outline concerns regarding this, I think, in the analysis they gave us this week. The definition, for example, around increasing the number of rooms, it needs to be clarified to ensure that existing rooms, for example, can't merely be partitioned. Also, the exemption from the rent pressure zone when the bear rating has been approved has been highlighted again by the organisation Threshold as a concern, because it seems as if a landlord could introduce a small change and thereby become exempt from RPZ increased limits. Threshold suggests, and I agree, that it should be defined that a property must be brought up to at least a C1 rating, energy rating, in order to improve the home and benefit the tenant with home energy costs. And subsection 6, of course, the section makes an offence to not comply with the section, or if a landlord provides false and misleading information, it can be an offence. Part 2, Section 5, of course, amends Section 41 of the 2004 Act and relates to the Part 4 tenancies, which, of course, as we know, is where the tenant has been in the property for more than 6 months and then becomes entitled to remain for up to 6 years, with termination of lease only on certain grounds. Section 5, of course, of the bill, and it's again welcome, Minister, provides for the extension of the Part 4 after 6 years have expired, and it will then be a further Part 4 tenancy, and it won't be restarted after 6 years with another 6-month period. It will continue simply as a Part 4 with those protections, and this is again a welcome provision. Part 2, Section 7, of course, amends Section 66 of the 2004 and relates to notice periods, and the new subsection 2AB provides for the landlord to remedy an incorrect notice and reserve it as a remedial notice within 28 days of termination order. I noticed again that Threshold had outlined concerns about that section and says that the use of the notice period should be given instead of, and I quote, a lawful notice period. It could lead to abuse of the section, Minister, something that you might address at committee. It seemed that tenants may only be left with 28 days to vacate a property, which isn't, of course, at all sufficient in the current climate. Subsection 2AC substitutes the notice period table for a new Table 1 table, and whereby some notice periods, of course, have been extended. Tenancies under 6 months are still entitled to 28 days. 6 months and 1 year, they've increased to become entitled to 90 days, up from 35. Between 1 and 5 years now gives 120 days, whereas prior to this legislative change, each year was entitled to a different notice, 42 days, 56 days, 84 days and 112 days respectively, and notice periods from 5 years and over remain the same as what has been set out in the Residential Tenancies Act 2015, where 5 to 6 years tenancies would be entitled to 140 days, 6 to 7 years to 168, 7 to 8 years 196 and 8 or more years 224. So again, these are marginal changes, maybe, Minister, but I notice that subsection 3 provides for you to review these changes, to complete a report and to later report for the Houses of the Oireachtas. Part 7, of course, is of the 2004 Act, is addressed, I think, in section 12 of the bill, which amends section 134 of the 2004 Act and provides for the registration of tenancies at the start of the tenancy and annually. And of course, this will mean that a landlord doesn't just register a tenancy once, but every year, and tenancies that were in place prior to the commencement of the section must also be registered, and there must be an annual fee of €40. But I noticed that there has been, again, there is some significant criticism, I think, of the provisions in relation to the rent register, Minister. I think a lot of us had been hoping that you would introduce legislation analogous or close to the legislation in the UK. The similar legislation, and I note that again Threshold asked that. They expressed disappointment, rather, that you didn't create a dwelling-specific rent register, and you're supposed to be considering that, I think, in the initial stages of the bill, Minister. So it's kind of regrettable that is not present in the bill, and that we don't have this dwelling-specific rent register. So Section 17, of course, provides the enforcement of the requirement to keep information updated, and it will be an offence to not comply with a notice served by the board. And Section 18, of course, inserts a new Part 7A, which I referred to earlier, I think, relating to complaints, investigations and sanctions under the 2004 Act, and sets out the interpretations and definitions, powers of the authorised officer, such as the ability to enter and inspect premises, and so on. Again, I noticed there in section, the new section 148AA, the appeal to the Circuit Court against the decision to impose a sanction, or 148AB, I think. All of those are important, I suppose, in creating some kind of an administrative system of invigilation and of being able to ensure that the actual legislation, the fundamental points of this legislation, and indeed the better points in the earlier legislation going back to 2004, are in fact implemented. I note that Section 19 amends Section 151 of the 2004 Act to insert the paragraph referring to the new Part 7A, and Section 20 of the bill inserts a new Section 164A after Section 164 of the 2004 Act, regarding, of course, the authorised officers and decision makers who will be appointed for the purposes outlined in Part 7A. So basically, Minister, in conclusion, and I know the Senior Minister has departed, but I want to welcome the bill. I will be supporting it, but I still believe it's far too little and very late in the present situation of our desperate homelessness crisis. But hopefully, even with the provisions which are here, it'll make that a certain amount of difference to the lives of tenants. I do think that it'll need to be accompanied, Minister, by a strong public awareness programme and campaign to ensure that tenants are aware of their improved rights, and of course it'll also need to provide the necessary resources to the RTB to ensure implementation and enforcement. I note in a reply recently to our colleague, Deputy Roisin Shortall, in March, Minister Murphy said that there were 55 staff at that stage in the RTB and 8 vacancies at that time. With obviously the new responsibilities that are being given to the RTB here and the strengthening of its remit, obviously there will be a need, I think, clearly for more resources and for a stronger role for the organisation to be able to address the rights of tenants. The Strategic Plan 2018-2022 of the RTB, of course, lists organisations supporting supports as a priority. So I'd urge the Minister to commence all sections, the ones I referred to, at the earliest juncture, to obviously avoid further fallout from our malfunctioning rental market. But I'd also ask him to maybe listen to the criticisms that have been made by members of this House of the key parts of the bill, and some of the issues that have been raised by stakeholders, and particularly by organisations like Threshold, that have long campaigned for a number of the improvements that are in this bill. Thank